Hello aspirants and welcome again to Legacy IAS Academy. In this current affairs lecture, we will be looking into the DPDP Act, that is the Digital Personal Data Protection Act of 2023. So this act is going to be implemented once the rules, the guidelines are ready. However, before that happens, there are questions with respect to the issue of privacy of individuals in this particular act. So we'll be digging deep into that. So what this news is all about, what has happened is that the member of parliament, that is Mr. Jairam Ramesh, has raised concern with respect to this act and has immediately asked for or demanded the repeal of section 44(3) of the DPDP Act. So specifically section 44(3) of the DPDP Act, what is this and much more is what we are going to see. Before we move ahead, a gentle reminder about the new batch that is going to start. So there are two types of batches. One is the regular batch. So two regular batches are going to start, one on 17th of April and the other one on 12th of May. This regular batch will be going on from Monday to Friday. That means 5 days a week. Morning 10 a.m. to 1 p.m. will be the first session, and then second session from 2 p.m. to 5 p.m. Now this batch is going to consist of everything that you require to clear your UPSC civil services examination. The entire syllabus will be covered, includes prelims test series, mains test series, includes your CSET preparation, essay, everything under one single program. So I hope this is clear. Moving ahead, now there are certain aspirants who do not prepare full time. They are, let's say, working professionals or having college commitments. For them, we have the weekend batch as well, which is going to start from 19th April. So these are the upcoming batches of Legacy IAS Academy. One more important thing for the UPSC aspirant of the upcoming prelims is the free All India mock test series that is being conducted. Get yourself enrolled with that, because with that you will be getting your All India ranking, along with it instant solution and the discussion, which will be very helpful to increase your marks in prelims. So without further ado, let's get started with our topic for today. So what is this Digital Personal Data Protection Act 2023, which has created a news yet again? So what happens is, there is digital footprint of almost everyone who has ever, or in fact everyone who has ever been on the internet. At times you may delete certain things, but remember, once you are on the internet, you can never be off of it. Even if you have posted a picture on the internet and later on deleted it, your picture still remains in the cloud. It is still stored. It may be deleted from that particular place, but it is never deleted from the internet. This and many more issues. Many times you download an app and it asks for various permissions, and left, right, center we start giving the permission without even reading what is actually written. What is written is to share your number, share your email ID, share each and every data that is related to you, utilize your audio, your video, etc., etc. So this has created a huge concern for all of us. Now, to protect this privacy of an individual, the government supposedly came with the Digital Personal Data Protection Act. Now, this act is supposed to protect our personal data, yet also make this data available as and when required for specific reasons. Let's say for the reason of national security, for the reason of apprehending a criminal, so on and so forth. So there will be judicial utilization of this data, at the same time ensuring that your data is safe with you as in within the country, and it is not gone abroad, and wherever it is safeguarded, the breach is safeguarded, so on and so forth, giving us certain rights and also providing certain duty on us, because if the data is required for national security, it will be taken. So that sort of strikes a perfect balance. So however, so this balance is perfectly strike by this particular act. This act tries to provide for processing of digital personal data in a manner that recognizes both. What two things? One is the right of individual. Your right has to be intact. At the same time, the processing can be done of the personal data with the purpose and matters that are connected therewith and incidental thereto, means related to the requirement or the need of the hour, it can also be utilized. So all that is fine, because the national security, of course, supersedes the personal privacy data requirement, is what we can say, in the need of the hour, not in a day-to-day life or day-to-day activity. Remember that. However, there has been a demand from the MP, as we saw, demand from the NGO, the social activists, at the same time demand from various NGOs like the Internet Freedom Foundation, etc. What are they demanding? They are demanding and basically the repeal of what? Section 44(3) of the DPDP Act. Now, what is this section 44(3)? We will see to it. Now, this section 44(3) of the DPDP Act, that is the recent act we are talking about, the act is of 2023 but is going to be implemented in 2025. Remember that. Name is 2023 because it was passed in 2023. Now, this section mentions a change in section 81J of the RTI Act. So, it is mentioning a change in section 81J of the RTI Act. Now, the question is, what is the section 81J of the RTI Act? We have to see. So, section 81J of the RTI Act. RTI Act is what? RTI Act is Right to Information Act, which gives us the right to ask for certain information which we may be seeking from public servants, information related to government offices, etc., etc. These information are then provided to us under the RTI Act. However, there will be certain information which may not be provided to us because of various reasons. One such reason is mentioned over here in section 81J of the RTI Act. It says that there shall be no obligation to give any citizen information which relates to personal information, right? Unless, means you will not be given certain information which relates to personal information of a person, of a public servant, unless, this is very important, this wording, this paragraph is still mentioned. You will not be given, but you can be given. When can you be given? You can be given when the Central Public Information Officer or the State Public Information Officer or the Appellate Authority, so these three, Central Public Information Officer, State Public Information Officer, or the Appellate Authority, is satisfied that the larger public interest justifies this disclosure of such information. So what is presently this particular section is saying? This section is saying, boss, that personal information will not be revealed unless and until the Central Information Commission or the State Public Information Commissioner or the Appellate Authority says that yes, it is required to disclose such information because of the larger public interest that is at stake. That means what? Ultimately, in certain cases, it was possible for this personal information of the public servant or government organization, etc., can be made public. I hope that is clear. So there is still some power in the RTI Act even to reveal the public information. Make sense? But what has happened under section 44(3) of the DPDP Act is this section of this act reduces the sentences that are present in section 81J. It reduces it and it increases the scope or the criteria based on which there will be denial of such information. It simply, what it does is, it says that this section 44(3) says that in section 8 of the Right to Information Act, in subclause 1 for clause J, the following clause which we just read, it shall be substituted with what? It shall be substituted with a single sentence: information which relates to personal information. Means what? Let us go back and have a look. It means that this entire thing that we just now read out will be changed to what? It will be changed to, there shall be no obligation to give any citizen information which relates to personal information, full stop. That means what? That means this clause is going to be removed. This particular paragraph is going to be removed. That means no longer will you be provided any personal information, even if that would have been justified, or even if that information would have been justified because of the larger public interest. You might have got the approval of the central public information officer or the state public information officer or the appellate authority, but still it will not be provided, because simply this entire thing now will be removed, and the only thing that will remain is there shall be no obligation to give citizen information, which is personal information. So the personal information about the public servant or the organization or members of the government organization will not be given. Now the question is, why are we interested in the personal information? See, the personal information here is not the information as to when the person gets up, what where he she or they goes, etc., where they die. No, the personal information here mentions the information with respect to the money they are holding, the wealth they are having, the net worth they are having. So that is very important. Why it is very important? Let's say a public servant enters the office and in the year 2020 presently and has a net worth of 10 lakh rupees. But after 3-4 years, the person has a net worth of 1000 crore rupees. Now, how is that possible? That will raise questions. So from where that wealth has come? What is it related to corruption? All those questions will arise when you get those information. But now what will happen? These information will not be made public. So how will you raise certain question when you don't have any information? So personal information also includes your personal financial information, etc., which will not be made public. As a result of which, this is going to dilute the Right to Information Act. That is why the opposition, the various members of parliament, the NGO, etc., are asking for repeal of this particular section. Now, this act has already been passed. Now we are in the opinion have been taken of the public in 2022 itself was taken. Various other steps have been followed. The act has been passed. Now these questions are being raised because the rules, guidelines, regulations are being set, and very soon they are about to be implemented. But it can clearly be seen that it is going to dilute the RTI Act. So probably it is high time that we re-evaluate this particular provision and come up with a modification or probably a repeal. Time will tell what happens with that. If it still goes ahead and gets implemented, probably the issue would be raised in Supreme Court in order to modify or repeal this particular section. Thank you.